Welcome to the deep dive. We are jumping right into the Manual of Patent Examining Procedure, the MPEP.
Yeah, and specifically we're looking at Chapter 700, which covers, the nitty-gritty of examining patent applications.
Exactly. And our target today is a really key section within that, MPP Section 716.
716. That's the one about affidavits or declarations under 37 CFR 1.132 and other evidence traversing rejections. It sounds technical, but it's really about a crucial tool for applicants.
A tool to fight back, essentially, when an examiner rejects your claims.
Precisely. It's how you formally bring new evidence to the table. Facts, data, expert opinion stuff the examiner might not have considered initially when they made their rejection based on the prior art.
So it's more than just arguing, it's presenting proof.
That's the core of it. Patent examination is, well, it's supposed to be a dialogue. And this section outlines how you, the applicant, can respond with hard facts or, comparative evidence.
Okay, important stuff. Now, we should probably mention the summary of the MPP we used as a basis for this deep dive was put together using AI tools.
Right. It's a fantastic guide for getting the concepts, but it's not infallible. Might have errors, might miss things.
So just to be clear for everyone listening, this is for educational insight, general information. It's absolutely not legal advice.
Definitely not. For the official word, you always need the actual MPP document itself, or guidance from a qualified instructor, or ideally, a registered patent practitioner.
Got it. And one more quick thing, a big thank you to Mike Shepard. He's the creative director who actually organized this whole MPP audio series that this deep dive is part of.
Yeah, great initiative.
Okay, so 37 CFR 1.132 affidavits or declarations. Let's unpack what they actually do in practice. What's their main role?
Well, their primary job is to traverse a rejection, basically to counter it, to overcome it.
When other ways aren't quite right.
Exactly. When the reason you think the examiner is wrong isn't covered by some other specific rule, Rule 1.132 is sort of the go-to mechanism for introducing evidence onto the record.
So the examiner issues a rejection, maybe says the invention is obvious, and this is your chance to bring in facts to show it's not.
You got it. You're introducing evidence. Could be factual data from experiments, could be comparative testing showing your invention works better than the prior art, could be statements from technical experts in the field.
All aimed at knocking down the examiner's initial case, their prima facie case.
Right. That prima facie case is just the examiner's first assessment based on what they found. The 1.132 declaration is your formal response saying, okay, but look at this real world information.
And these aren't just like casual letters, right? There's a specific format.
Oh, absolutely critical. It has to be either an affidavit, which traditionally means sworn before a notary, or more commonly these days, a declaration.
Declaration.
Yeah, it doesn't need a notary, but it must include very specific language. A warning, basically.
A warning about?
About making false statements. It has to state that willful false statements are punishable under federal law, specifically 18 U.S.C. Section 1001. The government takes submissions like this very seriously. Lying can lead to, well, significant legal trouble. Criminal penalties, even.
Okay, so you submit this formal declaration packed with your evidence. Now, the interesting part, how does the examiner actually look at it? What makes them say, okay, you've convinced me?
Well, they don't just check a box saying received. They have a duty to evaluate the substance, the actual content of the evidence you've provided.
To see if it genuinely overcomes the rejection.
Exactly. Does it factually address the points raised in the rejection? Is it persuasive? They have to weigh it.
And the MPP, the source material, it gives examples of how they communicate that decision.
It does. If they find the evidence sufficient, they'll often state it clearly, maybe using standard wording like, the affidavit filed on such and such date is sufficient to overcome the rejection of whatever claim number based on the specific grounds.
And if they don't find it sufficient,
then they have to explain why. They can't just say nope. They need to provide specific reasons for finding the evidence insufficient. That's crucial for the applicant to understand the remaining issues.
Let's dig into those reasons for insufficiency. Why might this evidence fail to persuade the examiner? What are common mistakes?
Several common ones pop up. First, irrelevance. The evidence might be great, but if it doesn't actually address the specific reason for the rejection, it won't help.
Like proving point A when the rejection was about point B?
Exactly. Another big one is untimeliness. There are deadlines for submitting responses and evidence during prosecution. Miss the deadline, and the evidence might not even be considered, no matter how good it is.
Makes sense. What else?
Lack of factual support is huge, especially for non-obviousness arguments. You can't just say your invention achieved unexpected
Like
results.
we need the data.
You need the data. Hard proof. Comparative data often works best. The source material even gives specific examples of what's generally not enough.
That's
Like a statement from the inventor just saying, yeah, my invention works the way I said it would. That's usually not persuasive on its own. It doesn't prove non-obviousness or distinguish it effectively from prior art.
okay. And another one mentioned was evidence not being commensurate in scope with the claims. That sounds important.
Oh, it's a major sticking point. Commensurate in scope.
What does that really mean in practice? Why is it tricky?
It means the evidence you provide has to match the breadth, the full scope of what you're actually claiming. Let's say your claim covers a chemical process working across a wide temperature range, maybe 50 to 150 degrees Celsius.
Okay.
But your declaration only shows test results at, say, 90 degrees Celsius, just 1 point within that range.
I see.
The examiner might argue, quite reasonably, that your evidence isn't commensurate in scope because you haven't shown proof that it works across the entire claimed range of 50 to 150 degrees. Your proof needs to support the claim as written.
So the evidence has to map directly to the language and breadth of the claims themselves.
Precisely. If you claim broadly, you generally need evidence that supports that breadth, not just isolated examples. Now, MPEP section 716.01 gives a bit more detail on these general evaluation criteria.
Right. 716.01. What does it emphasize?
Well, it reiterates timeliness, as we mentioned, but crucially, it hammers home the examiner's obligation to be specific when they reject the evidence.
They have to explain their reasoning.
Yes. No vague dismissals allowed. They have to point out the flaws, your data isn't commensurate, or this doesn't show a nexus, or this doesn't rebut the specific combination I cited. This helps you, the applicant, figure out the next step.
Okay, let's talk about that nexus thing you just mentioned, especially with objective evidence for non-obviousness, things like commercial success or solving a long-felt need.
Yeah.
That's a big use case for these declarations.
Absolutely. When you're fighting an obviousness rejection that's under 35 U.S.C. 103, bringing in objective evidence can be very powerful. Things like unexpected results, commercial success, failure of others, long felt but unmet need. If this evidence is timely and relevant, the examiner must consider it.
They have to weigh it in the balance.
Yes. It's seen as real-world proof that the invention wasn't just an obvious tweak, but, and this is the big but.
There's always a but. The nexus.
It's the nexus, yes. The source material is clear. For objective evidence to be persuasive, you must establish a clear nexus between that evidence and the claimed invention.
Okay, define nexus in this context. What's the connection they're looking for?
It means you have to show a legally and factually sufficient connection. If you're arguing commercial success, for instance, you need to prove that the success is because of the unique features you've claimed in your patent application.
Not just because of, say, great advertising or a sudden market trend.
Exactly, or because of features that were already known or are present in the prior art. The success, or the unexpected result, or the solution to the long-felt need, whatever it is, has to flow directly from the novel aspects of your claimed invention. Proving that link, that nexus, can be challenging.
So the evidence has to tie directly back to the claim's inventive concept. What else determines if the evidence is convincing? It's probative value.
Right, probative value, how much proof it actually provides. The key, as the source stresses, is actual proof.
Not just more arguments.
No, mere attorney argument or conclusory statements won't cut it. You need facts, data. If you're presenting objective evidence, like unexpected results, you need supporting data. And again, that data needs to be commensurate in scope with the claims.
I keep coming back to that. Commensurate in scope.
It's fundamental. And another point the source raises is the source of the evidence itself.
Meaning, who provided the declaration?
Yeah. Does it matter if it's the inventor versus an independent expert?
And does it?
Well, the MPP says an affidavit from an interested party, like the inventor, or an employee of the company applying for the patent isn't disregarded automatically. It's still evidence.
What?
But an examiner might give it less weight than a declaration from a truly independent third-party expert who has no stake in the patent being granted.
Yeah.
It's about perceived objectivity and potential bias.
That makes practical sense. Okay, so we've talked a lot about using these 1.132 declarations against obviousness rejections. Are there other places they show up?
Yes, while obviousness is probably the most common scenario, the source does note other uses. For example, in design patent cases, under 35 U.S.C. 171, if an examiner argues a design isn't ornamental, Maybe because it looks purely functional, you could use a 1.132 declaration to provide evidence of its ornamentality.
Interesting. Maybe expert testimony on design principles or consumer perception?
Could be. They can also sometimes be used to help distinguish your invention from a specific prior art reference cited under 35 U.S.C. 102, perhaps by showing functional differences not apparent from the documents alone.
Okay. And just to keep things clear, how does this Rule 1.132 declaration differ from a Rule 1.131 declaration? That's another one you hear about sometimes.
Oh, good distinction. They serve very different purposes. A 1.131 declaration or affidavit is primarily used to swear behind a prior art reference, meaning you provide evidence that you actually completed your invention before the effective date of that prior art document the examiner cited. It's all about proving an earlier date of invention relative to a piece of prior art.
So 1.131 is about timing, about beating the reference date.
Exactly. Whereas 1.132, which we've been discussing, is about the merits of the invention itself. It's about providing substantive evidence, performance data, unexpected results, expert analysis to argue that the invention is patentable over the prior art, regardless of the dates, usually focusing on non-obviousness or other substantive requirements.
Got it. So 1.131 equals timing. 1.132 is substance and evidence.
That's a good way to think about it. Rule 1.132 is your main tool for getting that real-world data, that expert opinion, that comparative testing in front of the examiner to show why your invention meets the patentability standards.
So wrapping this up, what's the big takeaway for someone navigating the patent system when it comes to MPP Section 716?
The big takeaway is that this section provides a formal, structured path to introduce critical factual evidence into the examination process. It's how you move beyond just interpreting documents and start showing the examiner real-world proof about your invention's characteristics and advantages.
Whether that's test data, expert testimony, proof of commercial success.
Right. All aimed at directly countering the examiner's rejection. It really underscores that getting a patent isn't just theoretical. It often involves demonstrating tangible results and benefits with solid evidence.
It highlights that back and forth, that dialogue aspect of prosecution, and gives applicants a way to put missing context or data onto the record.
Absolutely. It's a powerful mechanism, but it requires care, getting the formalities right, ensuring the evidence is relevant, factually supported, and crucially commensurate in scope with the claims.
Which leads to a final thought, maybe something for you listening to consider. Given how important this objective evidence can be, like commercial success or solving a long-standing problem, and given these strict requirements for showing that nexus and providing solid, commensurate data, how challenging do you think it really is for applicants to gather and present evidence that truly hits the mark, that's genuinely persuasive enough to overcome a tough rejection?
Yeah, it's often a significant undertaking. It requires foresight, sometimes substantial investment in testing or market analysis, and careful presentation to meet those USPTO standards. It's definitely not always easy.